Whether you are a law student or preparing for judiciary exam, understanding the preamble is a game changer. So let us simplify it and uncover its powerful meaning. So the idea of preamble was taken from USA and the language was taken from Australia. It is based on the objective resolutions drafted and moved by Pandit Jawaharlal Nehru and adopted by the Constituent Assembly. So it was adopted on 26 November 1949 and it came into force on 26 January 1950. So, the preamble is the soul of the constitutions. It is the brief introductory statement that sets out the objectives and guiding principle of the constitutions. So, the features of the preamble is the preamble begins by acknowledging the people as the source of authority. So, it is the people as the source of authority. It says that we, the people of India. So, the source of authority is the people. The nature of Indian state, it is sovereign. So it has the supreme authority over its internal and external affairs, and it is free to make its own laws and policies. So it is an independent country. The word socialist and secular was added by the 42nd Amendment Act in 1976. So the socialist is to achieve economic and social justice. It reflects states' efforts to reduce inequality. And secular means India has no official state religions and every individual has the freedom to practice, profess and propagate any religion. So it ensures equal treatment of all religions by the state. Democratic means power lies with the people. So it indicates that India has a government that is elected by the people, either directly or indirectly through free and fair elections, and it ensures participation of people in the governance of the country. And republic means the head of the state is elected. That is, in India, the head of the state is the president. So it is elected and not a hereditary monarch. The position of the head of the state is open to all the citizens. So the objectives of the constitution is justice, social, economic and political. So this was taken from the Russian revolutions. So justice in social. So social justice means elimination of social inequalities, whether based on caste, gender or class. And economic justice means to seek the gap between rich and poor, ensuring everyone has equal opportunity for economic advancement. And political justice means it ensures equal participation in political process and equal rights for all in the governance. Liberty, equality and fraternity was taken from French Revolution. So liberty means all citizen has right to freely express their opinion. It believes in any religions and practice their faith without fear of state interference. So equality means it ensures equality of status and of opportunity. This includes equality before the law and equal protections under the law. So all citizens, regardless of caste, religion or gender, have equal opportunities in various fields. And fraternity means it's about promoting a spirit of brotherhood among all citizens, ensuring individuals to work together for commonhood. So preamble was amended only once, that is by 42nd Amendment Act 1976. It added the word socialist, secular and integrity. If you see the role or significance of preamble, it is the guiding light. So it reflects the aim and aspirations that the constitutions seek to achieve. It is the interpretive tool. So court use preamble to interpret ambiguous provision of the constitutions. Let's see the landmark case law regarding preamble. So the first is the Birubari Union case. So Birubari is a small area in Jalpaiguri district of West Bengal. So after partition of India in 1947, the boundary between India and Pakistan was demarcated by Red Cliff Award. However, there was an ambiguity regarding Birubari Union area. Both claimed this territory. So the case arose out of a border dispute between India and Pakistan over the Birubari Union area. So there was an agreement for the division of Birubari Union. The agreement was known as Nehru-Noon Agreement. However, the question arose regarding the constitutional validity of transferring Indian territory to another country under the agreement. So the key legal issues was, does the preamble form part of constitution? Does the government have the authority to secede territory without a constitutional amendment? And what provision of the constitution governs the cessation of Indian territory? So these were the question arose with this Nehru-Noon agreement for the division of this area. So in this case, Supreme Court held that preamble is not the part of the constitution, and the territory can only be ceded to another country by a constitutional amendment under Article 368, and not merely through an executive agreement or legislations. But in 1973, it was a most important landmark case known as Case Vananda Bharati versus State of Kerala. It is one of the most significant judgments in the Indian constitutional history. It established the basic structure doctrine which limits power of parliament to amend the constitution. So this case addressed the nature of Indian democracy, parliament's amending power, and judiciary role in protecting the constitution. So here it was held that preamble to be the integral part of the constitution, and the key issue in this case was, can the parliament amend any part of the constitution including fundamental right, and is there any limitation on the parliament's power under Article 368? So it was held that parliament has the power to amend any part of the constitution including fundamental right under Article 368, but the power is not unlimited. So the amendment that violates or destroys basic structure of the constitution would be unconstitutional. So this was the landmark case where it held that preamble is a part of the constitution, and the parliament has the power to amend any part of the constitution including preamble, but it should not destroy the basic structure doctrine. So this is all regarding preamble. If you like this video, do subscribe my channel for more upcoming videos. Thank you.